Hello and welcome back to the Hill Law Group podcast. My name is Meredith Hill, and I am the owner and principal attorney at the Hill Law Group, an estate planning firm based in Bethesda, Maryland. We serve clients in Maryland, DC, and Virginia. And today we have Miss Ericca Pearson, another attorney at the firm, and we are going to talk about the exciting topic of a trust. What is a trust and who needs a trust? So let's just dive in. So exactly, Ericca, how would you describe a trust?
So I like to call it a will on steroids, kind of like. So I think that when people think of a trust, they think that it has to be someone who has all this wealth, and that is not true. A trust does what most people think a will does, and that is indicate, where does my stuff go after I pass away? You're able to do it with much more specificity. So you can say with, very much in detail how you want these assets to be distributed. And you get to distribute your assets. One of my favorite things is that you get to distribute your assets over time, as opposed to just in this one lump sum. So the trust is really an agreement with yourself. You as an individual, the grantor, sign an agreement with yourself as the trustee of your trust, and then you're also the beneficiary of that trust. So just think about the fact that you're putting together this alter ego, that you're creating this entity, almost like an LLC. And basically that trust functions to take care of you or take care of your beneficiaries after you pass away. So it can be a very, very beneficial tool. There's so many reasons why a trust can be helpful, can be beneficial to your scenario, which is why you always want to talk about it with an attorney when things are going well. But yeah, I think that's kind of explains a little bit about what a trust is.
Yes, I think you pointed out some important key information. You do not have to have a lot of money. You don't have to have a certain amount of money in the bank. And you want to make sure that you're doing it when you are of sound mind, you're healthy. You don't want to wait until things are going downhill and you don't really know what's happening. So you want to make sure that you're doing this now. And there's many different types of trust. The one that we're going to talk about today mainly is called Revocable Living Trust. And this is a great tool to use because you create it when you're alive and of sound mind. And as long as you are alive and of sound mind, you are able to take assets in and out of the trust. So one of the major questions that we always get from clients and prospective clients is, how much control will I have? Am I just losing everything to the trust? Is the trust going to be managing my life? And the answer is no. You are still in control. And so the trust is really like an instruction manual of how you want your assets divided up once you are incapacitated and when you pass away. So it's a really great tool to use. I'll talk about one of the major groups of people that need trust plans, and that I think we can both relate to this, is people that have minor children. So a lot of people think that when you have a kid, that you can just name the kid as the beneficiary on a life insurance policy or on your 401k or an IRA.
Many people do that.
A lot of people think that. And these insurance agents and HR professionals allow people to put minors as beneficiaries, which I don't think should be allowed, but it happens. But what happens if something were to happen to you and you were to pass away and your kid is young and under the age of 18, they are not getting that money right away. They have to wait until they are at least 18 years old to get it. So it's going to be sitting in an account somewhere, and your child will have no access to that money.
When they need it most.
When they need it the most. Additionally, whoever is serving as guardian of your child will have no access to that money to be able to care for their health, education, maintenance and support of that child. So the way we can make sure that we're supplying our children or providing our child with what we need, with what they need if something were to happen to us, is by creating a trust. And then we name the trust as the beneficiary of your life insurance policy, your retirement accounts, your bank accounts, all of that. So if something were to happen to you, all of that money would flow into this account. And then whoever is serving as your trustee of your trust after you pass away can follow your instructions on how you want the assets to be given to your children.
And that's a person you name. So you get
Yes.
to name the successor trustee. So remember, we said you're the trustee of your trust when you sign it, but you name the successor trustees as well. So you're able to say, these are the people who I know are can manage my assets well and will be able to make those distributions to my minor children. So it gives you that control that we're talking about. In fact, I don't feel like you lose control, you're gaining control with the trust.
Yes, you're gaining a lot of control with the trust, and you're able to leave assets to your children in specific ways. So if you want them to not have everything in one lump sum, when they're 18, you can divide it up in different ages and stages of their life. So you can have them get a little bit of money when they're 18, a little bit of money when they're 22, when they're 25. You can extend it out however long you want or however short you want. So if you know that you have a very responsible child who won't waste money, you can give them everything all at once. I don't really advise that, because if they're getting like your $2 or $3 million life insurance policy
At 18, it'll probably be gone by the time they're 20.
Yes, very much so. Yes, it's spent on just foolishness. So you're able to do that, and like you're able to make requirements and stipulations on them before they can get funds. So if finishing high school is important to you, or making sure that they work with a financial advisor, or they volunteer with some type of organization, or they keep a steady job. Because a lot of people think that, okay, I'm fine with creating a trust, but I don't want to have trust fund kids, but they're just lazy and
wait
they don't
around to get paid.
Yeah, they just wait around to get paid, and they don't have a work ethic. So you can make it a requirement that they must have a full-time job or own a actual profitable business in order to have their funds come to them. So it gives a lot of that control beyond the grave, and they're able to just access the funds as you have put it down in your trust. We could talk about this for a long time, honestly.
We could.
But for the sake of time, we're going to be moving on.
And that other group of people I think that need trust are people who have real estate. So if you have assets, a piece of property in your name, in order for that asset to go from one person, the deceased person, to somebody who's alive, you've got to name that person, or else it has to go through that probate process where the court is going to say, okay, these are the right people to get that asset. And a lot of times what can happen, oh my gosh, is if you have property and you have a lot of beneficiaries and you have nothing in place, or you just have the will in place, this piece of property is going to be owned by a lot of people. We have a case now where there are numerous people that if it gets beyond like 3-4 people where that piece of property is going to be owned by these beneficiaries, it's just creating really a mess. It makes it so that people are going to have to agree. And it's hard to get 4 and 5 people to agree on what to do with the property. And so what you want to do is, if you have that property, definitely indicate who you want it to go to. Maybe you want it to stay in your family. Maybe you want it to go to just the one person and continue to go through their bloodline, but you really need to be the one who determines what happens to this real property if something were to happen to me. And then specifically, if you have real property in more than one state, that you definitely need to put a trust together so that you don't not go through probate in one state, you don't go through probate in any of these states. So let's say, for instance, and we have lots of clients like this who have properties they may live in Maryland, may have property in DC, and then have vacation property in South Carolina or Florida.
See that often.
And what you want to do is you want to make sure that you have a plan, not just for the one property, but for all properties. And so you don't have to go through probate for all 3 properties. So it's really, you work really hard to get the real estate and to get that real property. We just want to be sure that after you pass away, that it's managed just as well and with your input and, after you pass away. So,
Mhm. Yes, yes. Avoiding the probate process, especially in multiple jurisdictions, is very important. So the trust administration process is administered privately. So you do not have to go to court. You do not have to submit your trust to the Register of Wills. Um, you just have whoever is named as the successor trustee of your trust follow your instructions that are in the trust plan. If they want assistance from an attorney, they can do that. So they don't have to, but they can. Um, and this moving outside of the court is a very beneficial thing because court can take forever.
It's just adding a lot of red tape and adding a lot of, it's almost like a second job. A lot of times people
it is. And
probate.
Yeah. And it takes at least a year, depending on where you're living. And so if you have property in multiple states, which happens quite frequently, you're going through this process in 3 different states. And that means you're paying court cost and probably attorney's fees at that point in 3 different states. And that adds up very quickly. As opposed to if you just had a trust, you would name the trust on the deed rather than yourself. And then when you pass away, you will have already written into your trust plan what you want to have happen to that house and who you want it to be given to, or if you want it to be sold or not sold. We have plenty of clients that want to keep their property in the family and only family members can live there or family members can rent it out. Because the family took so long to get the property, they don't want to have it just wasted. And so I think that's a good point about the real estate. And then moving to talk about probate a little bit more. So probate is that court process that administers your estate after you pass away. And you are going to go through probate if you do not have a will. If you do not have a trust. The trust is the only way that you can avoid the probate process.
So I think it's important too to note what you're here is if you have nothing, you're going through probate. If you just have a will, you're going through probate.
Yes.
If you have the trust, you bypass that probate process.
Yes. So, like we said, probate can take a long time. I had clients come to me at the same time. One had a trust and one had a will plan. The will plan took years. The trust took like a month. And that is just really, it shows you exactly the difference between the 2 plans. And we were just talking to someone the other day, and she was doing the estate for her mother who had a will, and her mom had passed, and her cousin's mom had a trust. And our client was telling us how it was just like a night and day difference of what she had to go through with probate with her mother and what her cousin had to go through with the trust process. So we just like to avoid probate as much as possible. I'm a former litigator and I like to avoid court as much as possible because it's just long and drawn out. It's so emotional. It's very, very expensive, especially if someone is fighting your will or fighting the estate. It can be a nightmare. And so then the last thing I just want to point out with trust is privacy. So when you go through the probate process, that is an open process, like
going to court.
Yes, it's going to court.
Yeah.
So when you file your will with the Register of Wills or whoever does that on your behalf, because you'll be deceased, it becomes a public record. So literally anybody who wants to can go to the Register of Wills, pull your will, see what you had, who you're giving it to, who's getting what. They can see all of that. And I know that sounds crazy, but there are people that actually sit out there and do this. They do this. And like can do this too. Like,
Absolutely.
yeah, and that's the worst, that's the saddest part about it. A lot of times it's family. And then they can go and fight your estate and really slow things down. The trust, however, is a private process. And so if privacy is a concern, I would highly recommend getting a trust
Mhm.
because you avoid having to file anything with the court. No one's going to see your trust unless you want them to see it.
Mhm.
And of course, your successor trustee is going to be seeing it, but um, outside of that, no one's going to see your trust.
Mhm. And then lastly, I know we just said finally the blended families. Blended
yes, blended
families
families,
are
yes.
also good candidates for trust, just because it can get sticky. Like just figuring out who are we leaving things to, how are we leaving it equally if you want to, maybe not equally. A lot of times we see that the people who are the beneficiaries who take care of the people generally are rewarded in the estate plans. And so again, when those blended families can sit down when everything is fine, everybody's healthy, there's nothing going on, it makes better soil, I think, for planting a good estate plan. It's just this place where we can think about, what do we want to do here? Yes, we want to make sure, and you put all of that in writing. It creates such calm, can create such calm and peace, as opposed to everybody fighting over everything and not thinking, oh, what am I supposed to get? Well, you have the plan here. And, I think blended families now are becoming more the rule than their exceptions, because there's so many variations of what a blended family looks like. And I would say the majority of them are very loving families, and that you want to be sure that you put this plan in place to make sure that everybody is accounted for, that, all of our stuff, or however we want to split it, that we've done it that way. So you want to just be sure, if you are a blended family, that you want to sit down, and if you want to make sure that everybody is taken care of and everybody is given their equal share or not equal share, or you just wanted things given away this way, the trust is a very good tool to assist in that process. So it's just something to think about.
It is. And it's a good way to make sure that your children are getting something, especially in the event of remarriage. You want to make sure that you're protecting assets that are specifically set aside for your children, no matter what the circumstances are. But I think we highlighted quite a few important people or groups of people that need a trust. Again, we can sit and talk about.
Yeah, I mean, if we could just come up with example after example. So
we love trust. We do here. And as we move forward, we'll talk about other types of trust and other things that come with trust. But we just wanted to address who needs a trust, because I think that is an important question that we get fairly often. So if you have any follow-up questions regarding this topic or any estate planning topic, feel free to email us at info@thehilllawgroup.com. And if you want to find out more information about our firm or schedule a virtual meet and greet with one of our team members, you can visit our website, www.thehilllawgroup.com, and also follow us on all the social media platforms @Hill Law Group. Okay, with that, we will see you next time. Bye.